Hey guys, Toby Mathis here, and today we're going to be talking about funding of trusts. And I just want to give the 10,000-foot view. In estate planning, there's really three categories you could fall into. The first category is the one where a lot of people do, unfortunately, where they didn't do any sort of planning. They don't have a will, they don't have a living trust, and they pass away, and their estate goes. It's called something called intestate, which means that they have no documentation, and you're going to be distributed under state law. Most famous case out there right now of somebody who died intestate was Prince, and his estate for years and years got wrapped up in just a big old mess. The other route is to have a will where you distribute according to a written document, and it requires a court order and a judge in a courtroom basically to sign off who gets what. It's called the probate process. And then there's number three, which is a living trust, where it is not probated. It is handled privately via that trust document, so long as it is properly funded, which is what we're going to be talking about today. So I have with me attorney John Anderson. And John, first off, welcome.
Thank you.
And the big one today is really going over the myths and the truths about trust funding. And I know that we've worked together for a long time, but let's make this into kind of a list, and let's go down the big myths that are out there and dispel them. And so I'm going to hand it to you to start that process.
Sure. So, probably the number one myth that I see out there that's promoted by even attorneys is that I can just rely on the pour over will or the schedules in my trust to fund my trust. And the problem with this is it actually doesn't avoid probate. The whole point of the trust is to avoid probate primarily. But if I just use the schedules to list out my assets and say, hey, these are all in my trust, that doesn't avoid probate. And I can kind of illustrate this. So let's say, for example, you have a bank account and you want that bank account to go to me after you die. And then you do something super nice and you go ahead and die. Let's say you wrote that down in a will.
Mhm.
So I take that will down to the bank and I say, look, bank, it says here that I get Toby's bank account when he dies. So give me the bank account, right? What's the bank going to do?
They're going to say we need a court order.
Right, they're going to tell me to go pound sand. Um, and so I've got to go to court. I got to go probate it. That will verify that it's valid, that it was the last will that you made. You didn't make another one, that I'm the proper beneficiary. And then I can go to the bank and actually get the account. Well, let's say you created a trust and you wrote on that schedule, this bank account goes in my trust.
Hmm.
And that's all you did. And after you pass away, I go down to the bank. I say, hey, look, bank, it was in a trust. And it says on the schedule that this bank account is part of this trust. What's the bank going to do? Exactly the same thing. They're going to tell me, go get a court order because we didn't know about this trust. How do we know he didn't make a new trust or he didn't revoke this trust? Or there's a lot of different possibilities out there, and they're not going to pay out twice. So they're going to make me go and prove it in the probate court and then come back and get the into the account. Now, if you create the trust and you actually go to the bank while you're alive and say, hey, I have a trust and I need to get this account into my trust, and they do some paperwork and get that actually transferred into the trust. And then when I go in after you pass away, they're going to check their records and say, yep, this account is in this trust, and the trust says that you are now the owner of it, although technically it would be the trustee who takes control of it. Show me a death certificate, show me ID, great. You now have access to that account without going through probate.
So if I'm hearing you right, then it's not enough just to list an asset out in the trust document. If it's held by a third party or if it's titled with a third party, you need to change that title.
Correct. So this is what we call funding. And a lot of times attorneys will give you a schedule and say, look, we put all your assets on this schedule,
Hmm.
and so you should be good. Well, what they're actually doing is they're setting you up because after you pass away, you're going to have to probate it. And then your family's going to go back to that attorney and they're going to charge another fee.
So you mentioned a pour over will, and
Mhm.
I know this is something that's commonly drafted with the living trust, and it's in a nutshell, a pour over will is essentially making the living trust the sole beneficiary of the estate, so that probating is easier, right? Now we don't have a whole bunch of beneficiaries we have to deal with. We only have one, correct? Is that why they're used?
So the pour over will is primarily there to catch any assets that may have been missed. Uh, a pour over will is just a will, and a will, in order for it to be valid, has to go through probate.
Hmm.
So if you just leave it up to the pour over will to transfer your assets, you have to go through probate. And yes, it will be more simplified, but a simple probate is still 10 times worse than just a trust, right? I've administered both. I would much rather just work through a trust that's properly funded than have to go through probate with a pour over will and then get it into the trust before I can administer it.
What are we talking about as far as expense and time wise? Just loose numbers.
So for a typical probate, $10,000 is typical a minimum in a lot of different states, especially if you have real estate. As far as time wise, it's going to vary a lot from state to state, but even some of the most simple probates that I've worked on, it's at least 3 to 4 months for a really quick one. If you're in a state like California, a quick one is 2 years.
Yeah.
So,
You always hear this. It's not a big deal in my state. Then you say, well, define not a big deal,
yeah,
right? It's like it's not a big deal for you. Might be, hey, this was not a 4 year ordeal for the lawyer, right? If it's less than 4 years, that might be insignificant, or less than 2 years, or less than 1 year. But for you, 2 months, 3 months might be a very significant period of time if you're going through the transition of an estate and there's uncertainty, and especially if you need access to the funds.
yeah. And then along those lines, if you have a business, your business can't operate while it's in probate. So if you have, for example, a medical practice, how many patients are you going to have left over if you can't do anything for 3 to 4 months, right? That practice is worthless at this point. Whereas if it's in a trust, they could sell it immediately after you pass away and transfer that over to someone else.
All right. So that's myth number one, is that pour over wills and schedules will fund your trust. What's myth number two that you see?
So the other one that I see quite commonly is that I can just use joint tenancy and avoid probate.
Hmm.
So you see this a lot where mom and dad have a home. They want that to go to the kids after they pass away, so they add the kids on the deed as a joint tenant with
Hmm.
rights of survivorship. And yes, this does avoid probate, but it can create a whole lot of other issues. One is that you just transfer the property to them while you're still alive, and under joint tenancy, every owner is 100% owner, which means if that kid for some reason gets in trouble, they have creditors coming after them, your home just became an asset of that kid that can be taken by the creditors. And I've actually seen it where mom and dad got kicked out of their home because they put the kid on there as joint tenants.
Hmm.
The other issues you run into can be tax issues. It's considered a gift as opposed to an inheritance. So you're going to get a decreased in step up in basis that you may not have been able to. If you would use a trust, you would get a full step up in basis. Um, it's public information, whereas a trust is private. So because you have the deed that you have to have recorded, everyone knows that it's going to that kid. The other problem is a lot of times people think, well, I'm going to just put one of my kids on there, but they'll make sure they're going to divide up the house between the other kids. Nope.
Just had that. One child put on it. Dad said he'll take care of all the other siblings, and he told them all to pound sand.
Yeah, because once they pass away, it's
Oops.
their asset. They don't have to give it to anyone or share it with anyone.
Like spouses too, right? Like all these things, all of a sudden you have assets that are part of the kid's estate as well, and it's like, whoops, they have any sort of legal problems, it's the parents' problem now, right? Too.
Right. And then the other issue is if for some reason something happens to you and the kid in the same event, right? You go on a cruise and the ship goes down. Uh, we're still in probate. Whereas with a trust, we're avoiding probate, but we also have contingencies written within the trust so that if something happens to the child, we've already got someone set up who would be the new beneficiary if the current beneficiary isn't around. So,
And this is a big one. It's not a topic for today, but I always think about this. There's a lot that happens to you during your life. The last thing you want is to be in a situation where you can be removed from your home by one by your kids, or you have medical issues or things, and you need to have access to that asset, and then you're blocked because the
right.
kid says, "Not that's my inheritance. I'm not going to let you take it." And you're like, "Wait a second, I need it." And they
Yeah,
say,
it
"Well,
can
joint
make
tenant."
for very tricky situations. So,
All right, so that's number two is please don't rely on joint tenancy. There's some situations maybe between a husband and wife that maybe, but otherwise, especially not with your kids. We've just seen too many bad things happen. But
yeah.
uh, anyway, so
So you need
don't
to
rely
make
on joint
sure, yeah, make sure if to get it into your trust, you have a new deed drawn up that lists the trust on there as the new owner, and that you get that recorded. In most states, there's a few states where you may not want to record it, but for most states, you would record that deed. That actually shows this property is in this trust and it should avoid probate.
and you just mentioned some there. We call it a pocket deed, where you draft a deed and you don't want to transfer it because there might be a tax implication for doing so with that particular jurisdiction. You hold it in your safe. When somebody passes, then you file the deed. It's effective all the way back to when it was originally
Right.
done, but you avoid having to probate it because you already have the signed documents. All right, what's number three? We've hit the pour over wills and schedules and joint tenancies. What's number three?
So this one is when you try and fund a bank or brokerage account into your trust, and the bank just won't let you transfer the account into the trust. They're going to go in and tell you, oh, you need to set up a whole new bank account, and you maybe have auto bill pays that are coming out of the account, auto deposits, that are going into that account, and you just don't want to have to go create a whole new bank account just to get it into the trust. There are ways of establishing the trust as the owner after you pass away without having to create a whole new bank account. And the way you would do this is you would set up what's called a POD, or a payable on death. Sometimes it's called a TOD, or transfer on death.
Mm-hmm.
And you, you go into the bank, say, I want to set up a POD, and I want to have this trust that I've created, listed as the beneficiary, so that I still own the account while I'm alive. I don't need to create a whole new account. But when I pass away, it says on the bank records, this account automatically transfers into this trust. Doesn't go through probate. The trustee can get immediate access to that account after you pass away. And we don't have to run into the issue of setting up a whole new account with new bill pay, new direct deposit, and all these other things that you may already have set up with your account.
That's really, really smart. So, like for those folks that are saying, "Hey, I just want to add somebody to my account," or try to, this may be a happy medium. It's like, "Hey, look, you keep your bank account. You don't have to mess around. Just go down to the bank and make a paid on death be the living trust, and voila, something happens to you. We're getting to the same place. We're avoiding going to court. We're not months and months of annoyance or out the window. We don't have to worry about that. The bank just needs a death certificate, goes into the trust, you give them your trust documents, and they can see that you're in control." Is that a
Yep,
summary?
correct.
All right. What's number four? I think we're at number four.
Yeah. So transferring a business into a trust will create tax issues. Uh,
So people believe that transferring, so this is the myth. Hey, if you transfer that business, you just did a taxable event. It was gonna trigger a bunch of tax if you transferred in there. That's
right.
the myth.
Either it triggers a tax or it changes the tax classification of the business.
Hey, I'm an S corp, and it has to be a normal person, right? And the
Right.
trust will destroy it. It's not true, right?
Right. Or it's a husband and wife own a business together, and if they transfer it into the trust, it will create, instead of a partnership, a sole proprietorship,
Hmm.
because there's only one owner. This is not true. With the trust, it is typically a grantor trust, especially if it's a living revocable trust, which means it's just a pass through. The IRS doesn't even want to know that this trust exists. They don't care uh,
Until
until you pass
somebody
away.
passes away, right?
Right. So the tax ID number is your social security number. When
Mhm.
you file your taxes, nothing is going to show up on your tax return that this is owned by a trust. If you get K1s or any type of 1099s, those still report to your personal social security number. So, for example, with the husband and wife, technically there are still two owners for tax purposes, the husband and the wife, because it's a joint trust, even though there may only be one owner listed on the actual business as being the trust.
Fantastic. All right. So that's number 4. And the myth is that it's going to cause some sort of problems with your business. That's not true. It's a grantor trust. It's ignored for tax purposes. What's number 5?
The number 5 is that if you have an IRA or 401k or even life insurance, you don't have to do anything with your trust because it already has a beneficiary. It'll just automatically go to that
I hear
beneficiary.
that all the time, John. I hear that all
Yeah.
the time. Don't put the IRA into your trust, and all that stuff. And it's like, yes, but, and then what's the but?
So the but is who's in control after you pass away. If you just name your kid as the beneficiary of your life insurance policy and they're under 18, the life insurance actually won't pay out. I actually have a family member that's dealing with this right now, where the mom passed away, the kids are younger, and the life insurance is just sitting there and they can't get access to it. And so just naming the individual, yes, will avoid probate, but it can create other issues down the road. So what you can actually do is, instead of naming the kid as the beneficiary, name the trust as the beneficiary. And the trustee will collect that life insurance or that 401k or IRA and then pay it out to the beneficiaries under the terms that you have set within your trust. So for example, if you didn't necessarily want everything to go to your kids after you passed away, and you just name them as the beneficiary of the IRA or 401k or life insurance, they get that. They can do whatever they want with it at that point. They can go and blow it. Versus if we have it go into the trust, your successor trustee takes control of it and then makes distributions under the terms of your trust, which may be a stretched out distribution, or you may be holding it for a period of time before they actually get full distribution.
Yeah, so that's really, and that's wise too. Like, you may be the beneficiary of your IRA. We're not saying make the living trust during your lifetime the beneficiary. You're making it a contingent beneficiary, right? So, like, the primary beneficiary on an IRA is you. Something happens to you, then where does that asset go? And there's actually some interesting court cases. I remember the Supreme Court weighed in on this as far as creditor rights for somebody that was a non-trust beneficiary. Like, they ended up being attachable, whereas when it went into the trust, the trustee was actually able to take action to prevent the asset from being collected by a creditor of the beneficiary. So, like, sometimes we don't know whether you're going to have a child or a grandkid or something else that's a beneficiary of your estate and they have creditors. You have no idea whether they're going to be going through financial problems. And that was like a wake up call for a lot of lawyers who were going, oh, we always just said, name them and it's not a big deal. Maybe it should be. Maybe we need to make sure that we're housing it in the proper vehicle so that we can prevent a creditor from just taking your inheritance. But your point is well taken.
In addition to that, with life insurance, for example, it's very helpful to have that go into the trust because it provides liquidity. Uh,
100%.
right? Because after you pass away, there's still debts that have to be paid, there's taxes that are going to be owed, and if you don't necessarily have the cash on hand to pay for those things and you don't have the life insurance coming into the trust, they may have to liquidate some assets, some stocks or real estate, and you may not necessarily want them liquidating those assets.
Yeah.
So if we have the life insurance pay out to the trust, that's going to provide liquidity and allow the trustee to pay off the debts and taxes without having to do a forced liquidation of other assets.
And there's just common sense. We don't want to, like, let's say we have $1 million life insurance policy. You don't want to dump it on somebody. And if you're trying to divvy it up amongst your kids and you have a complex estate, the last thing you want to do is give one kid a big pile of cash and the other one a bunch of problems.
Yep.
Right. So yeah, you could absolutely make a beneficiary that living trust, and that goes for your 401k, your IRAs, other. You'd make it a contingent beneficiary there. But for life insurance, you could just make it a beneficiary. It doesn't hurt anything from a tax standpoint or anything else. It's still non-taxable, but now at least you can control it. All right. What's the? I think that was number 5. What's the big myth number 6?
So this is where we have the biggest fights. It's that my family will have no problems dividing up my personal belongings after I die.
Hmm.
Um, most of the fights that I have seen is not over money, it's over the personal belongings. And I hear it all the time from people, oh, my kids get along well. They'll have no problems dividing up my personal property. And then you pass away.
Until they're fighting over the Christmas plates, right?
Right?
Until they're like, I want the plate. No, you, mom loved me best.
Yeah. The thing is that when you're gone, right, there becomes an attachment to those things because they represent you. And so while you were here, there wasn't that attachment. But now that you've passed away, your kids are now attached to those things and they don't want to just let them go. And so that's where the fights happen a lot. I've seen fights over a Parcheesi board. I've seen fights over a trash can. It gets crazy. And so if
What's the
you
craziest you've seen? Like, what's the one where you just sat there and you're like, I can't believe I'm having this discussion?
is a trash can.
The trash can. They were fighting over the trash
They were fighting over a trash can, right? It was a stainless steel trash can that had one of those pop-up lids.
can. Hmm.
Uh, I don't know why they were fighting over it, but yeah, I mean they were fighting over everything, but it was the
There was
fact that
a
they were fighting over the trash can that was
there was a
so
case in
ridiculous.
Georgia that was on a it was a plastic Tweety bird. I put this in a lot of my presentations. Like it was a little plastic. I taught I putty tat, Tweety bird. And the lawyer found an identical copy of it on eBay for like $3, and said, "Hey, there was a brother and a sister," and he says, "I'll just put them in a box. We'll shake them up and each take one." Nope. They went to trial on that thing. I don't know how it ended up, but the lawyer was just like, guys, $3. You think? No,
Yeah.
you want to be in front of a judge and fight over it? How do you avoid that with the living trust, by the way?
So typically within a living trust, you're going to have some type of we call it a memorandum of personal property. Sometimes it's a schedule where you can list out personal items and then designate who it goes to so
Hmm.
that it's set. When you pass away, Johnny gets the sewing machine, Mary gets the shotgun.
Hmm.
Uh, and then if they want to trade, right? They can trade as much as they want afterwards,
Hmm.
but that's entirely up to them whether they want to do it or not. And if they're mad about it, great. They can go jump up and down on your grave as much as they want, but it's not the kids, taking it from each other and being mad about it.
You also have a trustee in place, and then can you put some teeth in there to say if somebody does decide to sue their sister or their brother or their sibling or whoever else that you can there's a ramification for that.
Yeah, so a lot of times in trust there'll be a no contest clause saying that if anybody challenges any of these terms of how things are being distributed, that they get completely cut out. So if they do want to fight about it, they do it at their own peril.
Yep. That's the one that tends to do the trick is like, hey, you really want to do this because you're going to get nothing. I mean, you can go
Yeah,
ahead and do it, but it's unlike a will where they're inviting the contest. They're actually egging it on and then encouraging it in many situations.
yeah,
In the living trust, it's the opposite. And especially if you have a third party trustee who's not going to play games, they'll be like, nope, you guys want to do this? This is what the ramification is. And we're going to go ahead and burn your value of the estate. Like it's going to come out of your share. Anything else on that?
yeah. So there's another way of doing it as well, as far as dividing up personal property. Um, this is how my family has always done it, which is we have an auction. So when
Mm,
my grandparents passed away, everybody got $10,000 of monopoly money, and we just started auctioning off the items. So it's a way of assigning sentimental value to
mm-hmm.
assets as opposed to like dividing things up by monetary value. Because like you said with that Tweety bird, for example, with my grandma, the most sought after, the most expensive item was my grandma's cookie jar,
Oh my.
right? Versus, my brother actually went to Goodwill and he found the exact same cookie jar for like $2. Has
Yep.
no monetary value, but has a very high sentimental value. So by doing this family auction, it allowed us to say, well, I want it this much as opposed to other things, and I'm willing to,
How do you
use
put
up
that in
more of my
place?
funds.
Do you just have a trustee that says this is how we're going to do it, or I've seen people use cards as well, like and they do a up and down with the siblings, pick an item, and list them out.
Yeah. So my dad's a computer nerd. He
Mhm.
actually built a website for it for himself, for the
You're kidding.
family. That basically an eBay for the family, where we could just go on and bid. But and then it would track how much money you've used versus your total value and things like that. So we could do it over an extended period of time. Everybody could do it online from their home. I have seen it where they have everybody get together and they actually hold an auction at the house for the items. I've also seen it where you pulled names out of a hat. Those can work okay, but
Mm.
if
As long as
if
there's
you
a
can decide it,
process.
yeah, you need to have
Eh,
some type of process in place, or you need to specify and say these are the items that go
and the
to this
trustee
person.
can do this after the fact. The trustee can say, "Here's how we're going to divide it up."
Yep.
Right. This is the process we're going to use, and it can impose it upon the beneficiaries. Right.
Yeah. But if your kid is the trustee, I wouldn't suggest that method.
Yeah.
That's gonna create
If
all
they're the
sorts of
trustee, you're
problems.
not going to have that fight. Like if your kids are the trustees,
Right.
which begs the question: should you have beneficiaries act as trustees of the trust? But topic for another day, probably. Okay, so that's number six. We just went over. All right, so number six is my family will have no problem dividing up my personal belongings. That's the myth. What's number seven?
So this one is, as long as I have the big items in my trust, everything will go smoothly. Right. So the big items typically are real estate, bank accounts, and businesses. If I've got those in my trust, I'm good. I don't need, I'm going to avoid probate. Everything will go smoothly. And it is true. As long as you have those big three in the trust, typically you can avoid probate. But it doesn't mean everything's going to go smoothly. There are a lot of smaller items that can be very helpful to the trustee and the beneficiaries after you pass away that you may not think of. So, for example, your logins to your email or the password to your phone, things like this that you might not think about as being a big deal, but they can actually create a lot of issues if you don't do that.
So I'm going to just put this in the show notes, but we have an emergency binder that's absolutely free that somebody can download. It has all that in there. I mean, that's that. I don't want to say that's 90% of it. It's about 80 pages long, but it's an organizer that you can use to organize who your doctors are, dentists, things like that. But it goes over your social media accounts. It doesn't have your password in the binder. It actually has a separate password sheet that you can put and store somewhere, perhaps inside your living trust, perhaps in a safe, perhaps with your trustee. But it does not have your username and passwords together. It has the passwords on a separate sheet numerical. So it doesn't even like somebody finding that they wouldn't know what your username or what it's even to. They'd need the emergency binder. But that's absolutely. I'll put that into the show notes. You know that we like to give stuff away, but or if you want to, I'll send you the link. You can just type in emergency binder into the comments. Just put emergency binder down there and we will send you the link. Absolutely free. You could use it to fill out because this is a big one that John is talking about. Those little things can cause you months and months of strife, or worse yet, you're not able to get access, period, right?
Correct. Yeah. So, for example, with a social media account, if they don't know how to get into the account, it can be just sitting there for months, or never be deleted or removed.
Like
So
Meta or Facebook, whatever you want to call it, I call it Twitter or X, whatever. Like they have terms of use, and a lot of the times it's non-transferable. So
yeah.
you see these accounts just don't get anything, and you see other accounts where they get in, and it's usually the kids or somebody saying, "Hey, I'm just posting. This is such and such going to be the memorial of this individual and something." And let people know that something happened as well, but impossible if you don't have the login information, especially that password.
And they can also help them find things. I had a friend whose father passed away, and I was helping her out with some of the work. Luckily, she did have access to her dad's phone, and on the phone were the emails. And
Mhm.
eventually there were some invoices that came in through that email about some storage units that nobody knew about. And they were able to find those storage units because she had access to the phone. If she didn't have that, those storage units would have defaulted. No one would have even known about it. Everything in there would have just been auctioned off,
Yep.
and everything would have been lost.
It would have been storage wars. You wouldn't even know it.
Yeah, it would have been on an episode of Storage Wars.
Yep. All right. So that's what was that, number 7? So let's go to number 8. What's the 8th myth that you hear about most about trust funding?
So that I should keep my trust in a safe deposit box.
Ay, ay, ay.
The problem with the safe deposit box is in order for someone to access it, they have to, one, have the key, and two, they have to be listed with the bank as an authorized opener. And
Mhm.
so if I leave the key to my trustee, but I don't actually name them as an authorized opener, they cannot go and get the trust documents. And they probably will have to actually go through probate just to get the trust.
Mhm.
So if you are going to keep your trust in a safe deposit box, make sure that you have your successor trustee listed as an authorized opener on that safe deposit box. Um, my suggestion typically to people for your trust is keep it somewhere safe that you're not going to lose it, but not so safe that nobody can get to it. So if you put it in a gun safe in your house and nobody knows the combination to that gun safe, it doesn't do you any good if they can't get to those documents.
Again, the emergency binder does cover that, guys. It does have in there locations of things and how to access safes and how to access safe deposit box. Obviously, with the safe deposit box, you have to go to the bank and get that. But even knowing that it's there is sometimes half the battle, because people will go through and not tell their family members where they have accounts, where they're, where they're maintaining bank accounts, or other types of accounts, business accounts, whether they have safety deposit box, whether they even have a safe. I found
Yeah.
many a safe behind a wall, on properties that we purchased. You find them in the floor, you find them in different places, and you're like, oh my gosh, I wonder if anybody knew about this, right? A lot of
And
times the answer is no.
I have a friend who bought a condo in Florida and he keeps getting mail from the previous owner. And the previous owner had passed away, and there's a brokerage account with a decent amount of money sitting in it, and then
Mm.
no one has ever claimed it. He keeps getting statements for it. Um,
Eventually, that'll go to the estate. Go to the state, right?
yeah,
Eventually, but
yeah. It's been decades
yeah.
since this happened, and it's still he still gets the mail for it. So
So the moral of the story is, don't put your living trust in a safe deposit box. If you put it in a safe, make sure somebody knows it's in there and how to get into that safe. Otherwise, I usually just tell people, leave it on your shelf in the area where you transact business in your house. Like if you have a home office, or if you have, well, this is where I write in my checks or keep my checkbooks, or do my bill paying or whatever. Put it there where somebody can see it easily. Some people are worried about the public seeing their. What if somebody steals it? All right, we'll print it out and you can sign it again, right? It's like,
yeah.
it's not the end of the world, but it's certainly putting people way behind the 8 ball if they can't get a hold of your documents, um, and
And
especially if they're locked away someplace that they had no idea even exists.
And I would recommend keeping, create an electronic copy of it and keeping that on like a cloud or some type of outside um, location, because if, for example, your house does burn down and your trust burns up with all your documents are gone, you can still what we call restate or recreate those documents as long as we have the electronic signature showing when it was signed and things like that.
Yeah,
So not all is lost because you lost your documents. Don't try and lose your documents. That's a whole nother issue that I've run into a lot where people just misplace it and they have no idea where it's at, and then they pass away. But keep it somewhere safe, but not, if it does burn up or something happens to it, it's not the end of the world as long as you have an electronic copy that's stored somewhere else.
fair enough. All right, so that's number 8. So that brings us to number 9, which I think we're doing this as 9 myths. So this will be the last myth to cover. What is that ninth myth?
So this is dealing with foreign assets. As long as the foreign country recognizes trust, then I can put my assets in that foreign country into my trust. That is not true. They may recognize trust, but a lot of times the issue you run into is how do they tax those trusts? So for example, in Canada, it's a common law country like the United States, right? They have trust just like us, but they tax them very differently than we do. And you actually are going to get hit with a huge tax bill if you try and use a trust to hold your assets. So you got to be careful of not just realizing, okay, they will let me own it in a trust, but how is it going to be taxed? So I would be careful of transferring any assets that are outside of the country into a trust that was created specifically for the United States, because they're going to have different rules, and we wanted to make sure that you're not going to get in trouble.
And there's things like personal property that are pretty easy to transfer. You can hold in a trust, but there's things like real estate, businesses or interests in that jurisdiction, physical property that's located in that country that are going to be governed by those local laws, which means you need a local practitioner to make sure that it meshes and works well. It's the flip sides too. Is in the United States, we see this all the time. The rules are very different if you're not a green card holder, not a resident, not a citizen. The estate tax exclusion is ridiculously low. I think it's 60,000 or something like that. So somebody foreign has $1 million worth of U.S. assets. The tax bill on that's going to be close to $400,000 just for showing up. And so there's definitely something where you want to talk to a practitioner. The same could be true in another jurisdiction. So make sure that if you have foreign assets that you're talking to somebody in that jurisdiction. Do you agree?
Yeah, yeah. Don't just rely on putting it into your trust and hoping everything will work out okay. Because a lot of times it actually doesn't when we're dealing with foreign assets.
All right. So that's, let's see if I can do this. 9 myths that John just hammered away. I want to say thank you so much for covering those. Any parting words for anybody out there?
Yeah, make sure you do this. Don't put it off, and but also don't feel like you need to do it all at once. You know, do this in pieces, right? Create the trust, and then maybe get that all done, and then worry about, okay, let's fund the big assets first, right? Let's get the business and the bank accounts in there, and then we can worry about, okay, let's work on the personal property next, and then let's work on this next piece. Don't feel like you have to get it all done all at once, but break it up into pieces, focus on each piece that you need to get done until you're completed. And the best thing is, once you have all this done, unless you want to change who like the beneficiaries are, there's not really anything that you have to do. You kind of, it's like the old Ron Popeil commercials. You set it and you forget it.
Great advice. If somebody wants to get a hold of you, I'll put your email in the show notes as well, so they can just reach out to John. If you want to talk about a living trust with John, actually, I'll make it even easier. Just write living trust and put it in the comments. Just type in living trust, and John will send you a link so that you can schedule something with John, so you can talk to him about whether or not it makes sense for you. Guys, as always, please like and subscribe. And if you think somebody could benefit from this information, please share it. Again, this stuff is out there to help the public so you can make great decisions and you can make a great legacy. Thanks again, John, for joining me. And I really appreciate you going over the 9 myths about funding a living trust.